Hello and welcome to Passing the Bar, a video lecture series brought to you by Delaware Law School. My name is Professor Brett Bendistis. I am the Assistant Director of Bar Passage here at Delaware Law School. And I'm bringing this episode today with a lot of different things. We're going to cover a lot of things that seem really complex, but we're going to try to simplify them and to make things and questions you may have this part of your bar studying process just like a tiny bit easier, right? I want to note something that a lot of the things we're going to talk about today are mostly like my opinion on complex topics. And so I want to note the idea that like you might differ from me in a lot of ways. A little bit that's going to be subjective. A lot of things that are going to be really good rules, but it's some study habits and some ways to think about MEEs, thinking about lectures, think about the MBE, and then we're going to talk about your civil procedure question. That's going to be like a little bit more objective in the future, but we're going to talk about a few things that you may want to think about when it comes to how you're studying for the bar, how you should approach things, because again, you might have no idea what you're doing. Very normal approach, especially when you are doing something that you've never done before. And my goal is just to like make things easier and to give you some suggestions. One thing that I will note is that what I do a lot of now is that I've been meeting with a lot of students and talking about things. And so I learn a lot from the feedback that I get from people. And so I will note if you're watching this video and you're saying, well, hey, I have a question for Professor Bendistis and I'd love to run some things by him. My email is here. It's inverted. So like I don't know which side is which. My email's right here. You can always email me. You know, I'm more than happy to answer any questions. I'll touch base with you on anything. The number one thing that I will also do is review any writing samples. That's a big thing that I can do that's super easy. And that's going to come up a little bit later. And so the number one thing I want to note here and that we're going to talk about is like study habits, things to approach the bar exam with in a real particular way. I know when you're like how to watch lectures and how to take exams and how to do civil procedure, that might feel dry, but I think there's going to be a lot of substance today and things that I really want to cover that's going to be helpful. Now, the first thing I want to talk is this. The part one of this video was the civil procedure question that is posted to your Canvas page. Now, a part of that civil procedure question was that instead of being given an outline, and again, that was a real civil procedure question, you had a lecture video from Professor Margaret Zhang who gave very tailored lecture on the topics that were supposed to be addressed in that question. Okay, now, the reason why I did that is I talked about this last time and I want to talk about it again. I think it's hard to think about the idea of like, what are you supposed to do when you're watching video lectures? My experience, just for the maybe fifth time that we've been doing this, is that I went to Delaware Law School and that when I took the bar exam, we took it in class. And so what I would do is I did it 2 summers. First summer, we watched mostly lecture videos. It was Pennsylvania, New Jersey. And then the next summer, it was Delaware. So it was like half videos, half in-person lectures. And they were mostly covering distinctions that we needed to know. So I always think that lecture videos is that it's a starting point to think about like what you're doing and why you're doing it. Okay, now, the first thing I want to note about lecture videos is that I often think is that like you have an outline, right? And that in all instances, like you should have a good written section of most of the material you have. And so my personal opinion, I'm going to show you the notes that I have for Professor Zhang's outline that I took, and I want to kind of think of some things, is that I think that the notes you take for this, especially because you have another outline and you have other materials, shouldn't be about rewriting elements and rewriting rote materials, especially if it's slowing you down. Instead, thinking about the outlines more along the idea of like, how is it that you can understand the law, right? What are the materials that come from the outlines that maybe you say, well, this isn't in my outline, but this is something else. This is this practical person's experience that talks a little bit more than I can get from just the rote memorization of the elements themselves, right? The bar exam is a professional exam, not an academic exam. Again, that's a personal opinion that I have about it, meaning that so far in law school, you know, the people who are testing you want to know your understanding of the law. They want to know that you've been in class. You know, the bar exam is so practical. They want to know that you can practice law. And so I think that there's a distinction here of that you've got to show a bar examiner that you can be a lawyer, not that you can memorize law and show them the facts that might connect it, but that you've got to be able to say, I know what this means and I'm able to represent it to you, not so much in my own words, but using the necessary terminology, but in a way that shows you my understanding of the law. That to me is the most important thing that you can practice. I think the problem that I have read, a problem that I've read in some bar exam questions, some bar exam answers I have, and again, problems in the sense that I want to make sure that if you know the law, you're not running into trouble in the bar exam because you can't express your knowledge, right? That's a lawyer in a nutshell, right? You can know all the law in the world, but if you can't express it in a way that's persuasive, in a way that's convincing, well, then sadly, you're not a very good lawyer, right? So the point that I think the bar exam wants to know is like, are you good at expressing something? I'm going to tell you a small anecdote really quick that I learned a long time ago that's always stuck with me, right? I had this case, and I'm going to be vague about it, but I think the point that I think remains, right? It was a case that involved a very dense and technical real estate statute in Delaware, all right? If I showed it to you and you read it, you would be like, I don't understand what any of these, like it's barely like English. It's so confusing, right? And so this very established lawyer filed this lawsuit pursuant to the statute, and myself and my clients read the complaint, and we were like, this doesn't make any sense. Like none of it made sense. What the person was asking for didn't make any sense. The statute didn't make any sense. And so we went to the first case and we won. Like and everyone was like, none of this makes sense. You get the point. They appealed to the Superior Court. We go before a judge, right, who has since retired. I told him this story recently. I saw him in the courthouse when I was volunteering for something. And the judge comes up and he's like, I don't think this makes sense, but I think there's something here. And so he goes to the lawyer and he's like, and if you can make this sense to me in this meeting, like whoever is more convincing today wins. And I realized, I was like, oh, there's something more to this than maybe I'm understanding. And so the other lawyer comes up and very much in his own words is like, this statute has three parts. There's this part, and this part. And when he was done talking in 10 minutes, I was like, damn it, I feel like maybe he's right. Right? Because he took a statute and he spent the time to explain what it meant to the judge in his own words. He used the terminology, he used the language, but he made it so it was easy to understand. And the lesson that I learned like as a lawyer is that there's more to the law than rote memorization. There's about being able to convey an idea to someone so it makes sense to that person. That's your job as a lawyer. It's not a matter that I want you to change the language and I want you to reorganize like what's there, but I also think that your approach has to be instructive. You have to teach the reader that you know the law and that your conclusion is correct. I also tend to think when it comes to outlines, the part that you really want to be getting toward is writing about the law in practice by practicing your rule statements. One thing that I used to do, and I did this for the bar exam, it was very laborious. It took a lot of time. But what I do is I write multiple outlines. And so when I write multiple outlines, the reason why I would do it is not that I'm writing the same thing over and over again, but I'm like consolidating the understanding of it, right? With the idea being that if I can take a big long outline and I can say, you know what, contracts is only these three things. And within those three things, there are only like 3 or 4 things that I really need to think about. It gives me a better perspective of the entirety of the law and the entirety of the issue. Again, another point that I will just tell you is like doing that was the first time I understood evidence. Like, I don't think I really understood evidence practically until I studied for the bar. And then when I became a practicing lawyer, I always felt like evidence was like a really strong arrow in my quiver because like I knew it and I got it and I was able to use it. So the point that I will note is that when it comes to doing these outlines, one of the reasons why I think that it's a matter of don't try to get everything, but try to get enough that you can then consolidate that into the material so that you have good, strong rule statements for the future. Now, when I say rule statements, I mean that you have practiced writing the law before you sit for the bar exam. Now, on some topics, I think that you can maybe get away with not doing it if you run out of time. Like, for example, what do you think your strongest topic is? Person watching YouTube? Like, is it like torts? Like maybe you can write about negligence and that's easy for you. Torts I think is kind of like that. Criminal law I think is kind of like that. Like if you know the elements, you can write about them. The difference I think is something like property, something like civil procedure, where if you don't have experience writing these really dense topics in a way that is instructive, that makes sense, that shows your understanding, I think you're going to not sound as clear or persuasive as you need to. And I don't think that the memorization of terms, like about zoning hearings, right? That's not fun, right? Or mechanics lien. Like if you're just writing the memorization concepts and you're not practicing what it means for your understanding, I think the problem you're going to run into is that you're not going to sound like you understand it. And the point is that you don't want to just sound like you understand it. You want to sound like you know it, that you get it, right? And so that's the key that we're going to be working on. And that's a little bit of what we're going to talk about a little bit today. Now, what I do here is I want to change my screen a little bit. I'm going to show you the notes that I took for Professor Zhang's lecture. And I want to point out a few things that I think might be helpful. Okay, so these are my notes, right? And I want to point out a few things that like I didn't fix these. These are exactly the way that I wrote them. And I want to note a few different things that I have here. First off, a lot of what I tried to focus on really particularly was a way of writing my understanding, not just copying the PowerPoint. And trying to think of phrasing and things that I liked of how Professor Zhang said thing of how I wanted to talk about it, right? Like here, she talked about federal subject matter jurisdiction is about whether it's the right case. Personal jurisdiction is the right place. I like that phrasing. I want to include that later, right? Also thinking about diversity jurisdiction, 2 requirements, amount and citizenship. I highlighted also stuff that I thought I could supplement later. And the reason why I bring that up is that amount and citizenship, I know that probably seems like, well, there's so much more to it. There is a lot to it, right? I get that. But I think that the specific phrasing and copying the language is something that I think I'm going to do later. I'm not going to do that right now. And so the point that I'm really having is that I'm trying to sort of make sure that as I'm writing notes, I'm writing how do I understand the issue? I'm not just writing the memorization. What are the key terms I have? Because in many instances, and again, unlike law school, you may have an outline that you can supplement all this with, and so you don't have to write it the same way. And so I think about the notes that I take is about filling in the blanks of the things that are important, right? Another thing that I think is here, like service of process. Process of notifying defendant of the claim so they know the claim could implicate an interest. That's a really important word, right? Big problem if not satisfied. These are things that, again, the lecture said that I want to fill in the blanks, and it's not just the rote definition that I can get from Rule 4, right? Rule 4 is there. I'll get it, right? The point there is that I want to show the bar examiner that I understand not just the term, but the practicality of it. Even here, leaving at home with person of suitable age doesn't have to be the person, just trustworthy. That's the key thing that I think is important. And one of the things that I use for the bar exam question is that Professor Zhang had mentioned, like when it talks about serving on the office, she talked about board of directors, CEOs, and high-level employees. That's reading between the lines and showing an understanding that's more, again, than just the outline, right? Other points here that I also want, it's like the Erie Doctrine. One of the things that I wrote on the Erie Doctrine when I was taking notes is I didn't want it to be like, okay, well, this is just the definition. I wanted to talk a little bit about what my understanding of the Erie Doctrine is. When in conflict, state wins on substantive law, federal wins on procedural law. Like I even know there's a typo there and I'm fine with it, right? The point that I want to reference more is that that's my description. That's how I simplify it. That's how I make it easier. And I'm kind of getting a few things that I think are worth it. I even have the Hannah case here because I want to show the bar examiner, if I need to, that like I know a case that might be important. I think a thing that I thought about when I was taking the bar that I would think about the bar is it's a little bit like filling up a stat sheet, right? Like you're up against a rubric in many ways. And so thinking about the idea of like, how do I show this person I really know it, I think is the most important thing that's really there. Again, a few other points here. Constitution, bringing up the fact that it's the last chance defense for the defendant. Representing the idea that it's if the rule's good, but it seems weird, that's the problem. So the point that I want to note with all of this is that I'm trying to take notes on, especially if the concept I think makes sense to me. I'm trying to take notes that convey or represent my broad understanding of the law. I'm not just copying words and thinking that that's enough. Because I often think that the way that you can write and that shows that you get it is, hey, I understand this, not the exact memorization. So again, my notes in general were a way of summarizing big concepts, not slowing down, not pausing the lecture. And then if I felt like I needed a little bit more, like again, if I was really writing an Erie Doctrine question or I was writing an outline, I highlight it and I know to myself, hey, when the time comes, maybe add a little bit more technical language to the Erie Doctrine. I'll even tell you third-party complaints. When I wrote the question, like when I wrote the essay, I did go back and I was like, hey, let me go back and get a better definition because I don't have a whole lot here that's super great. And so I think that's my approach. Again, I don't think it's a matter where like you have to do exactly what I'm doing, but I also tend to think that if you find that what you're doing doesn't feel effective, be open-minded to trying something different that maybe you've never done before. Take a small detour before I get back into that civil procedure question. I want to talk about two things that people have talked to me about that I just wanted to address really quickly. One requires notes, one does not. The first thing I'm going to talk about, this comes up a little bit with civil procedure and in the idea of why are you rewriting things, what's worth memorizing, right? I think some of the things that worth memorizing is like the MBE to me is worth memorizing a little bit, right? Because I think a lot of the MBE questions are really technical and really specific. And I have a suggestion of something that I did when I was doing MBE questions that adds a little bit of extra to a suggestion that I'm sure you've got like 1,000 times, right? So the number one thing that I think when you're doing the MBE, the multiple choice questions that people tell you is they say, go back and figure out why you've got something wrong. Okay, great. It's great advice. You should do it. Okay. The thing that I would add, and not just being like, oh, how did you get something wrong, is that like I had a notebook. Okay, I'm a bit of a Luddite. I know that I look like I should know how computers work because I'm like bald and I have glasses and my beard's overgrown. However, I usually use like a pen and paper for like most things, right? Especially when I'm trying to think of something, right? And so what I did, and again, if you can use Microsoft Excel, kudos to you, because it might be a better way to do it. But what I would do is I would take big chunks of MBE questions, right? I do like 50 or I do 100. I did a lot of example exams where I would sit under real conditions that I've talked about before. But what I would do when I was done is, yes, I would go and I would figure out why I got something wrong. But I would have columns on a piece of paper for all of the topics, all 6 topics, right? And I would not just keep a tally of what I got wrong, but I would also keep a tally of why I got it wrong in a few different ways. Now, 20 years ago when I took the bar exam, I did easy questions, hard questions. Meaning, did I feel like in hindsight I should have known the answer, but I got it wrong anyway? Okay, that would be an easy question. Other ones were like, you know what? I could have had a million years on this one and I would have gotten it wrong. That would be a hard question. Okay, here's why I did that and a few different things to think about. I did that because I think it's worth noting when you are making mistakes and when maybe you just don't know something. Okay, I will tell you this: like when I took, like I do LSAT tutoring. I've taken the LSATs as like a lawyer to see how well I could do, and I feel like there are just some questions where I'm like, I know what I'm supposed to be looking for, and I just don't really know what the answer is. Cool. In those questions, I think it's a matter of like you could put more attention on it because you're like, well, these are hard and I want to do better. But sometimes I think of the idea is like, if you know that you're getting easy questions wrong that you should be getting right, those are the questions I put more attention on. For example, I think that MBE criminal law questions are deceptively tricky, right? Like I know criminal law like the back of my hand, right? But sometimes I read a prompt and I'm like, okay, I get it. I didn't read this part. I read something, I assumed the rest. And what I noticed is I was like, I'm getting a lot of easy criminal law questions wrong. And that's a problem because to me, easy criminal law questions are what's going to build up the bulk of my score. And so what I noticed also is that I was like, well, I'm getting hard property questions wrong. You know, put your hands up if that's you too, right? But the point is that like if I see like Blackacre and a descendant, fee simple subject to condition subsequent, I'm like, listen, I'll give this a shot. But at the end of the day, if I know I'm not good at the real dense ones, I'm going to do it, but I'm not going to get stuck, right? I'm going to give it my best shot. And if I have time, I'll go back. But to me, it's a matter of like, if I know I'm getting things wrong that I shouldn't get them wrong, that's the things I got to know. The other thing I also think is that like, I would also make a distinction on, did I misapply the law or did I misunderstand the question? Right? Because most for me was the second one, right? I read too fast, I talk too fast, and I assume things that shouldn't be there, right? But again, if I'm looking at it, I'm like, hey, criminal law questions, I'm misunderstanding the question. Maybe hearsay questions, I'm misunderstanding the law, right? All right, well, I got to study that. I can fix that problem. And so I think in some ways, I want you to think of the idea because if you're just reading the answer and you're like, oh, I should have gotten that right, and then you're leaving, I don't know what you're really learning from that, aside from the fact that you got one question wrong that you should have gotten right while practicing. And so to me, again, it's a big tally of all of your progress to make sure that you can see what you're doing right and what you're doing wrong. Let's go back to the essay question, right? And then I'll do the other study tip in a little bit toward the end. Three essential essay writing concepts, right? Three things I want you to think about, right? Issue spotting, rule development, analytical application. The idea is, are you addressing everything that's important, right? Are you giving rules that have depth to them, right? Broad legal statements and practical ways to prove the law. And is your application analytical? Are you applying facts to support your conclusions? Are you giving answers that are indicative, that show your understanding of the law? The big thing I will note, I love analogies. And so this one falls, I apologize. Sometimes I think about like when you're giving me memorized rule standards and then facts, restating the facts. To me, that's like going to a restaurant and being like, here's the flour, here's the sugar, here's the eggs, and the griddles in the back. Have fun making pancakes. It's like, no, man, I'm here so you can feed them to me, right? So the idea is like, I want your writing to do the work. I want you to make the law easier. I want you to make it more analytical. And I want you to think very specifically when we talk about essays in general, is like, what is the form that you are using? Form is so important. And so in a lot of ways, I think you might be doing essay questions and you're like, and you read the samples and you're like, hey, same conclusions, same topics, but it might not be. And the point that I will note is that like, if you feel, you can think about whether or not this applies to you or not. I think some people it does, some people it doesn't. So I don't want to assume anything. There are people who I think that their grades don't represent their understanding. And to me, that is a writing problem, right? It's a communication profession, right? And so if you feel like you get it and you don't understand why you got the grade you got, I think that's a matter of communication, whether you're able to write something correctly. I tell this story, and I'm going to give a really abbreviated version of it. I had Alicia Kelly, Professor Kelly for property, right? And I got not a terrible grade, but I got like a C my first semester, and I was stunned, right? Because when I got done that grade, I thought they were going to like frame it and hang it in the Rubyvale courtroom and be like, this is the smartest kid we got here, right? And so I sat with her for like a quick second and I was like, hey, can you just tell me what I did wrong? Because I don't understand. I don't understand like why that's that. She sat me down. She showed me the rubric. She explained why my writing, what could do better. And what I found is I was like, well, I can do that. I just didn't know I was supposed to do that. And after that, I got nothing but like A minuses and B pluses, right? It's like the tiniest meeting and it completely changed the trajectory of my life. And I tell Professor Kelly that often. I'm sure she loves it, right? But the bigger point that I will note here is that like, it's just about writing sometimes. And so I think in some ways, if you've gone like the entire time and you've always wondered that question, again, email your mentor or email me or Professor Lofts. And I think some of the writing concepts we can talk about are here. A few things I will note, right? When you look at your writing, and I would always suggest like do these MEE questions because I'll have samples and I don't care about your substance. I don't even care if you have the right answer, right? What I want to care about here, I'm going to care about your answer in general, but for now, I care about like, how are you actually writing? How are you like putting the words on the paper to explain your answer? Like look at the first sentence of every one of your paragraphs. Does it serve a purpose? Does it look the same all the way through? Does the first sentence of an application section tell me a random fact, or does it give me a substantive conclusion, right? I'm going to give you some samples that you can use. Do you have paragraphs that serve no purpose, right? Get rid of those, right? And are you addressing all possible answers in the question? Are you being thorough, right, in a way that's conclusive? I'm going to show you again what I mean by this in a quick second. But I want every paragraph to mean something and to mean something in IRAC form. Put some thought into what you're conveying. The other thing I will talk, and we mentioned this before, your writing needs to convey your understanding of the law, not the memorization of the word. Meaning that I want to make sure that like you're not just saying, well, I know what a third-party complaint is. I'm good. I want you to tell me what a third-party complaint means in practice. I think of civil procedure in two ways. Let me give you two small stories here. because again, what are we doing, right? Sitting here on YouTube. First off, I think of civil procedure as something that in law school seems impossible and in practice seems kind of easy, right? Like I've written a lot of civil procedure motions, and aside from like a motion for summary judgment, but like venue motions, 12B, anything other than 6 motions, discovery, third-party joinders, all that stuff, it's pretty on the nose, right? In that I think that when you see the standard and you work it in practice, personal jurisdiction, like when I was in law school, was this like, it was like Lord of the Rings. It was like the story was so long. I don't know that a bar examiner or a judge needs you to be like, Kumo tire, right? Tell me what the standard is and tell me how it works, right? Unless Kumo tire is really applicable for you. But like I learned the general progression in law school, and that's not really what I need to be doing if I just need to convince a judge that my case shouldn't get dismissed, right? So first off, you can simplify it. You can make it a little easier. Again, within the context, make sure like you check with somebody that you're doing it right. The other thing I think about civil procedure is that like if you go all the way back to my first slide, right? Here, there's a podcast I have with a buddy of mine that I met at law school, right? His name's Nazem. He went to Delaware Law School with me. And one of the things that we used to like to do together is we would play like very obscure European board games because we're cool, right? But the idea is we used to play this game called Twilight Struggle. It's like one of my favorite board games of all time. But we would play all board games the same way because we are lawyers interpreting the rules, right? We'd set the board up, very friendly. Right? Me and Nazem, best buddies. And we don't argue that much, even though we have a podcast. We don't fight, right? Except we're sitting playing a board game. We play, all friendly, good. One person would make a really influential move, and the other person would pause for a second. Both of us would do this, by the way. And then they would reach over and pick up the rule book and make sure that either that person didn't do it right, or if there was an argument we could make to undermine the good rule. And it wasn't like it was once. It was like every 15 or 20 minutes to the point where it was like, we have to stop doing this because we're like going at each other's throats. I think that's civil procedure in a nutshell, meaning that it is show me how the rules work and be instructive about the rules. But if you're like the defendant and someone's doing something, can the rules maybe like save your bacon a little bit, right? Can you cut someone's legs a little bit out from under them, right? That's my experience with a lot of civil procedure. It's sort of like, well, how do I win on a technicality? And how do I make sure that these rules make sense together? Right? So in the essay that I'm about to show you, I want to know 2 different things, right? One, the practicality of my answers and what I'm trying to argue, but also the structure of everything and how every paragraph and every sentence works together for a really particular purpose. Okay, so first off, I can't go over this like sentence by sentence. So the first thing I would suggest is go to Canvas and just read this. Right? Again, this is all part of your studying, just something to think about that helps you figure out the things that you're going to do. The key thing I want to notice, like if the first question service of process, right? I look at my sentence structure in a few different ways and my paragraph structure in a few different ways. First off, each of these paragraphs is a very particular point, right? The first paragraph here that I'm going to show you my mouse, this is a first rule paragraph, right? This is the easy application paragraph that shows very specifically what the easy answer to the question is, right? It's the federal rule. This is how the federal rules applies. The second part goes over the Erie Doctrine, right? Now, the reason why we're going over the Erie Doctrine, if you haven't gone over, is because it's kind of a counter argument that the other side's going to make. If you've gone over the civil procedure question, they were compliant with the federal rule, they weren't compliant with the state rule. So the idea there is that I'm phrasing it in the idea of the reason why Erie Doctrine is relevant here is because it is an argument the other side's going to make, but I'm going to talk about why it's wrong. So this is my counter argument rule and application paragraph, right? I'm going to do this all in one paragraph. Again, you could certainly break them up, but I wanted to kind of put this all together because at the end of the day, it's more legal than rule-based, right? When I can split them up, I like to, but I also want to make sure that very consistent points are together. Because this is a counter argument, I thought I could do it well, but in the same token, if you feel like you need to be flexible, you can do that too. The last point I will note is I did the same thing here with an argument under service being unconstitutional. I addressed every point that Professor Zhang brought up that I thought would be relevant because I think a judge would assume that you would get all three of these arguments, right? Again, people are going to throw everything against the wall to make sure that it sticks. To me, the constitutional standard is another thing where, like, I don't think I need to fill up the score sheet with a deep understanding of the standard, but I do think I have to address it, right? And so the addressing it here to me is a matter of, once again, really kind of being particular about, like, here's the law, here's why it's wrong, but giving you a definition of the word and then applying it after the fact. The other thing I will note here is, like, look at my topic sentences. The issue is whether the company's motion to dismiss for insufficient service of process will be granted when the complaint was served on the company's CEO and not the secretary as required by state law. My first sentence defines the issue from the perspective of someone who knows the answer, right? I don't know if you know what Chekhov's gun is. Chekhov's gun is it's a literary device for a Russian playwright where he would have guns in the first act and they would kill someone in the third, right? That you'd see it coming. I like to think of my first sentence as being written from the perspective of, like, I want the bar examiner to say, first sentence, this person gets it. Now, you could certainly start with a conclusion, right? I don't have any problem with that, but I also like to start my application paragraphs with conclusions. So to the extent that you can do one or the other, that's your comfortability, but I like this phrasing because it shows, again, the bar examiner, I get it. I understand it, and I can convey it to you really clearly. You'll also note here, this is my conclusion on the federal rule. This is why the Erie Doctrine counter-argument is incorrect. This is why the other argument is incorrect. And so again, paragraphs, organization, clarity, right? Same thing kind of here, right? I started the same issue as with a broad issue that covers all of the points that I would note. It's for lack of subject matter jurisdiction, so I qualified that I'm going to talk about federal, supplemental, and diversity. I think it's important to note here that yes, diversity is the answer, but I also want to tell the judge, the examiner, why everything else is incorrect, right? So for here, this is my rule paragraph on both on federal question and supplemental. What's the issue, right? This is my application on both of them. Key thing that I want to note, right, is that all of these sentences are aimed at being like an answer. This is true because, this is true because, this is why it's different. And so it's not just a matter of, like, given the facts, but trying to write something in a way that uses the law to develop an answer, right? Same thing here. I have my rule paragraph on diversity jurisdiction, and then I kind of add that into an application section here. Now, one of the things that I will note is that, like, you know, diversity of jurisdiction is a tough thing to write about sometimes. I often found that the practice of what I've learned, right, is how do I simplify this as easy as possible? To me, I thought it was a matter of consistency, right? Diversity jurisdiction is proven because this corporate citizenship is A, company citizenship is B. Medform citizenship is A because, here's all the reasons why. Corporate company citizenship is B because, here are all the reasons why. Here's why Medform is wrong about state A being incorrect. Meaning I'm just giving my answers. I'm telling why they're right. I'm disqualifying the bad answers. So every sentence matters. There's organization here so that's easy to follow. I think that this is the kind of thing where, like, if I had another diversity of jurisdiction question, I got a plan. Right? I know how to write it. I know how to apply it. It didn't take me a lot of time to do it. Like, I timed myself and I made sure I was in the right timeline. But the other thing is that, like, the next time I have a lot more time to spare on other questions because I know what I've done here. All right. Now, third question. Truth be told, I went into this thinking a different conclusion. Right. But then I was like, no, actually, I think that's actually wrong. And I think in general, one of the things that I think is important to note is that, like, sometimes you're going to find that, like, you have somewhat of a different answer. But one of the reasons why it's good to practice rule development beforehand and how to approach questions beforehand is that it gives you time to change your mind if you think that maybe you're incorrect. This is another thing of, like, how do you write specifically something you know the answer to? As a lawyer, one of the things I've always struggled with is, like, how do you write obvious things? You know, you're going to have cases sometimes where, like, you're arguing to a judge why the sky is blue, and you just want to be like, hey, just look out the window, right? And so this to me is an answer where it's like, why are these things different? It's hard to develop, but that to me is the kind of thing where you have to give yourself time to really think about this application because it matters. Because I was writing it and I went back and I was like, I think I'm just stating the facts over and over again. And so I was cutting out sentences that I thought were just, hey, this is just restating the facts. I got to do a little bit more than that. And making sure that my sentences are analytical in a lot of ways. So once again, here's my suggestion. Go back and read this, not for content, right? Note it for form. Why are the sentences there? How do they work? And to note the fact that, once again, every question starts with an issue that is forward-looking. Every application is a detailed answer and conclusion, right? I often think of legal writing isn't written like a movie where you build to the conclusion. Legal writing is I say the conclusion and then I explain it afterward. I had mentioned before that I do a Supreme Court podcast. I only do this here. So this is a terrible way to do something. I don't get paid for my podcast. It's purely recreational. When I have to read like a Supreme Court decision for the podcast and I don't have a lot of time, I will sometimes just read like the first sentence of the paragraphs and be like, am I getting a gist of what's going on? Is it following the syllabus? Maybe if I'm reading a concurrence or a dissent. The idea being that like it's so topic sentence based. And so in a way, that's how you want to write. And so think about this the next time you write an essay. What is the first sentence of every paragraph? And is it serving a purpose? Or is it just doing something that's either repetitive? Can I add more to it? Or is it just a fact without any analysis? Okay, I leave you with this last point. I'm back on this slide here. I don't have a slide for this. This is something that a few people have talked to me about. And I want to kind of just give you my 2 cents at the end of the day, right? I had a few people who asked me questions of like, is it okay to take a break? It's okay to take a day off, right? And here's my general understanding in my memory and a few little anecdotes about what I can remember, right? So again, I took the bar 2 times. My first summer, it was odd because I felt like graduation was so much fun. It felt like there was like life and energy in the law school and like my practice and like I loved everything that I was doing. And then it felt like when I went to bar prep, it was like everybody was like a zombie, right? Nobody's having fun. Nobody's going out. Nobody's doing anything exciting, right? And all that like energy that came from being, in law school was like, nope, no more fun. I think at the end of the day, it's good to have times to do things that are enjoyable for yourself, right? And so, yes, you do want to study 8 to 10 hours a day. That's like a job, and if it includes the weekends for 2 months, again, that's not the end of the world. I think you have to understand like who you are as a studier and a procrastinator at the end of the day, right? I often think of it as the idea of when I don't want to do anything, I apologize if you've heard me say this. A professional does their job when they don't want to do it. When I don't want to do anything, sometimes I do easy stuff, right? Things that I'm like, hey, this isn't like the hardest thing in the entire world. I can kind of do this half paying attention, half not paying attention, or I can do like a little bit of it just so the day isn't completely wasted. If you're like, next Tuesday, I'm doing nothing, but then you wake up on that Tuesday and you're like, I feel pretty great. That to me doesn't seem real smart. That seems like the kind of thing that you're locking yourself into taking a break when you don't really need a break, right? I think of it as more of a matter of like, note what your tolerance is and what your study habits are. If you feel like you're a great studier and you're feeling you're ahead of time and you want to have a lighter day, hey man, like no one's going to come find you. The only point that I will note is that like things do get crazy pretty quick. I remember being in July and I will qualify this by saying I've never been a religious person, and I only say this because it makes sense in the story, right? And not that there's anything wrong with that, but I was studying and I had not seen a person in like a while. It was like a couple days of me being like in my apartment in Carpenter Station Road, where like 95 meets Naaman's Road. I don't know how many of you are familiar with that, right? And so I lived in this apartment where there was like a door on the street. I was the only place that had a door on the street. So if you like wanted to talk to people, you could like knock on my door. So solicitors came, they were Jehovah's Witnesses, and they knocked on my door and they were like, hey, can we talk to you about like, religion? And I was like, yes, please, right? I was so lonely and like deprived for human connection that I was like, let's do it. And so I sat with these people for maybe like an hour, right? And was just like, hey, here's what I'm doing. I'm not very, again, I'm probably not going to go to church, but like you've got my attention for as long as you need it, because I just like I need a break, right? And at the end, they were like, "Hey, can we say a prayer for you?" And I was like, "Yeah." Like, "Can we give you some literature?" I was like, "Why not?" Right? And my point here is that like it gets real dense later when you start feeling like you're under the gun. And so like I'm recording this on Memorial Day, right? If you need a break now, hey, I get it. But note the fact that like it is going to get pretty dense later, and the more ahead you can get now, um, it can give you a little bit of free time later, especially when things start getting a little crazy and they get a little harder. So, that's my best suggestion. Other people might disagree. And so I will note that if your mentor is like, don't take any breaks, keep going. Again, each person's different. I can read fast and I knew what I was doing. Like I had a plan. So the point that I will just note is that again, I think that there's a matter of like, as long as you don't feel like you're falling behind, you can do whatever makes sense. You know yourself better than I do, right? But be honest with yourself and note the fact that like if you need a break because you're burnt out and you can't work, I think that makes a lot more sense than pre-planning breaks because you like just want to treat yourself. Because again, things get crazy a little bit later. Now, my email is right there. Please email me if you have any questions. A thing I will note is that like whatever mentorship things you need, if you feel like you're not getting them anywhere else, you can always email myself or Professor Lofts, and we can do our best to give you the things that you might need or be helpful with, right? Because the key thing is that here at the law school, we want to help you. Like our job is to make sure that you pass the bar. We are not going to let you sink if you don't want to sink. So please use whatever resources you have available. Please watch more of these videos. I'm going to post more lectures. I will do them all through the summer. But I'm not going anywhere. So good luck with everything. Check out those essays, and then good luck. I know that everyone's going to pass, and you're all going to be fine. And we'll keep talking in the future. Sounds good. Have a good rest of your day.